All right, a minute. Let me check this. Okay, I welcome you all to the Estate and Gift Planning Awareness webinar on the theme, Estate and Gift Planning for Wealth and Sustainability. This is part of the Estate and Gift Planning Awareness Month campaign. And this is in collaboration with the Teacherpreneurship Network. So CFLE Africa and the Teacherpreneurship Network is organizing this webinar to share some nuggets and create awareness about estate and gift planning and how we can build wealth and sustain that wealth over a period of time. And today we have some great speakers with us who are going to help us expand on estate and gift planning, digest the topic for us. And I hope by the end of this presentation, you will pick some lessons that will help you manage wealth, that will help you distribute your wealth, and that will help you share your assets and also build generational wealth that can help you leave a legacy behind. And so our agenda today is basically to look at estate and gift planning, a case study presentation. And we have an amazing lawyer, chartered banker, a lecturer to do this for us. Then we will take question and answer session from participants on estate and gift planning. You will then go into overview comprehensive financial planning. What does a comprehensive financial planning entails? And we have the executive director of the Financial Awareness Foundation to help us demystify this concept. And then we will do some Q&A, and then we will wrap up our presentation for today. So to help us with our first presentation on estate and gift planning, a case study presentation. And just recently, we had the National Estate and Gift Planning Awareness Conference, and he was one of the speakers. He did a great job. He shared a lot of real-life experiences and case studies about estate and gift planning. And today, we are happy to have him share this nugget with everyone. Without wasting much time, we will invite our first speaker for today, Mr. Richard Atta, or Richard Atta Esquire, to take us through estate and gift planning, a case study presentation. So, Mr. Atta, if you are with us, kindly put yourself and help us understand what estate and gift planning is all about. Thank you very much.
Good evening. Thank you very much for this opportunity. Before I start this program, I need to say that there's a saying that failing to plan is planning to fail. Whatever you do, if you don't plan for it, then you are planning yourself to fail. This presentation is basically on personal wealth, your own money, your own estate. So it's not that other person's wealth, you yourself. So an estate encompasses all aspects of persons, entities, assets, properties, and interest. The 9th edition of the Bright Law Dictionary defines gift as the voluntary transfer of property to another person without consideration. It's a means to transfer property rights and interests. So the essence of estate or estate transfer is for you to do it voluntarily. You know, in law, before you transfer something to somebody on commercial basis, you have to look at consideration. And consideration is something you look at before you enter or agree to accept a transaction. But in estate planning, is your own property and you want to transfer it. So it should be voluntary. Nobody should put any stress on you to do it. By in doing it, you should be able to give the property to somebody when you are not alive. The person can sustain or keep the property the way you had wanted it to be when you are alive. That is why you have to plan for it. That is why you have to organize it well. That is why you have to put measures in place so that when you are not there and you can see, if you are in another world and you can see this world, you'll be happy to say that this is what I wish and this is what has been done for me. Before an interest can be transferred as a gift, the law is much about the interest of the donor. The person who is giving the property, the law is about this. This is guided by the maxim, nomi dat quid non habet, meaning you cannot give what you do not have. So for any planning, you have to give what you have. If you don't have, you can't give. So what do you have? And what does the law say when you have? This maximum principle has been enacted in Section 1 of the Wills Act. Any person of Section 1 of the 1991 Act 360, it states, any person of or above the age of 18 years may, in writing and in accordance with this act, make a will in disposing of any property which is his, or to which he may be entitled at the time of his death, or to which he may be entitled thereafter. So it should be your own property. And the law, the emphasis is on 18. Before I go on, I need to make some little explanation about age. You see, in Ghana, when you are less than 16 years, you are treated as a minor, or when you are less than 18. So that is why when a girl is less than 18 years and even consent with sex, to have sex with somebody, the law says that is defilement because it is assumed that that girl is not of age. But in our constitution, the age that is acceptable is 18 years. In Britain and other jurisdictions, they say that when you are 21 years, then you are an adult. But in our Ghana, we are saying that once you are 18 years, you are minor. So we don't look at the ages of 18 and 21 per se, but we look at 18 years, at the age of 18, you are minor and you can do whatever. But in other jurisdictions, they have the 18 years for minors and 21 years for adults. There's another thing I need to explain. If you're a young man in Ghana and you are less than 18 years, you can't marry. But if you are more than 18 years and you want to marry, you have to seek the consent of your parent. But if you are 21 years, you can marry without the consent of your parent. So this is something we should understand. But when you want to write a will, that one, you should be just 18 years. The army, the police, and the armed forces also have their own way of allowing people to write their own will. In that case, once you enter, whether you are 16, 12 years, and you are in the armed forces, they will give you forms you fill and you dispose your property so that in case you die in the war, your property will be disposed. It's similar to SNIT, where when you join the scheme, they also give you form and you fill. That will not be part of your estate per se. You can still mention it in your will per se, but you cannot change what you have given either as a soldier or as a pensioner. To this effect, it is essential to know that the distribution of estate and gifts must be well planned before undertaking. So you need to sit down and plan how the estate should be distributed. You don't use anger to distribute your property. You don't use emotions to distribute your property. That is why it should be planned. And in planning, we have stages of planning. You have to set your goals and you have to know what you do when you are not there, how your property should be distributed. With the distribution of matrimonial property, Article 22 of the 1992 Constitution also stipulates that assets which are jointly owned during marriage pendency of marriage shall be distributed equitably between the spouses upon the dissolution. When you say equitably, equitably is different from equally. And when you say equitably, we are saying that what is due you. So it is saying Article 22 of the 1992 Constitution say that when you get married, you don't normally, it's the men who write the will. Women don't like writing will. It's the men who write the will. And when they write the will, sometimes they may not give some to their spouses. Article 22 is saying that when somebody writes a will and you were a wife during the pendency of the marriage, you can invoke Article 22 for you to be given equitable share of the property, not equally. You know, most women think that when they become wedded wives, they automatically have access to all their properties. No, it's not like that. When you have your property, you decide whom you should give to. There's a case of Bosumchu Sam in Western region. As at the time he died, he gave the property to the girlfriend and the children. He didn't give the wife. And that was his wishes. In that case, the Constitution would say that because the wife was still a wife during the pendency of the marriage, he could invoke Article 22 for an equitable share of it to be given to you. But make no mistake, if you are Mrs., it doesn't mean your husband's property is for you. No. And you must also understand that when you enter into a marriage, there are some properties that has been acquired before coming together. Although religiously, they will say that when two people marry, they are one. But when it comes to ownership of property, you only become one when you agree to merge the properties. Now, let's look at so many ways by which properties can be gifted. In Ghana, we have when you willingly give the property, and when you don't do it, and the law will do it for you. So we have ways where you yourself would decide. That is where the planning comes in, how the property should be distributed when you die. If you don't do that, the law will do that for you. That is where you have the intestate succession law. So if you don't write a will, if you don't donate the gifts before you die, and you die, the law will come and distribute the property. So if really spirit exists, you'll be in the other world where your property will not be distributed the way you want. It is for this reason that we are saying that you should plan and organize yourself and distribute your property the way you want it. The first way in which property can be gifted or distributed is what we call inter-vivos gift. The vivos gift is a type of gift where you give the property to somebody before you die. And it can be done either in a written form or in an oral form. So when I want to give a property to somebody, I can decide to donate it to that person as a gift. That's what you have, the gift deed. So you allow a lawyer to prepare a gift deed. So you have two properties. You want to give one to your firstborn, one to your secondborn. You don't want to write a will before you give it to them. So you can prepare a gift deed and give it to them before you die. So immediately you die, the ownership has been transferred from you to them already. So you don't need anybody to come and read any will to say this and that. That's why most cases, that's what most lawyers do, or most elite class. They distribute their properties long before they die. Another way of distributing property is to do it orally. In our parlance, we normally call it samanso, where you call people and you tell them that, look, I'm giving this property to my first son. And it is assumed that when you do that, the person whom you give the property must thank you before you die. So assuming I have a cocoa farm, and I want to give it to my son, I have to call a relative of mine, a relative of my son, a relative of my wife, assuming even I'm not with my wife, and then a third party who doesn't belong to any of the family, then you donate the property to them orally. After that, he will also come and thank you with a token. Normally, they bring drinks, sometimes with cloth, either can take cloth or maybe sheep. Then the animal will be slaughtered as an evidence that the property has been given. One thing about this intervivals thing that once you make the donation, you can't reverse it. The only time you can reverse it is when probably the person is your child. But if you make a donation to a third party who is not your child, you can't reverse, especially when ASEDA or where the gift deed has been signed and registered at land, but you cannot change it again. We can cite cases to support this thing. In the case of Sassy versus Sassy, the plaintiff was a young man. The father wanted to go and take a loan at a bank, but he didn't want to use his name on the property. So he transferred the property to his son and allowed his son to guarantee the loan. Later after that, the son wanted to take the property. The court held that, look, your father never intended to give this property to you. We are giving instances where people do certain things and they do not have, in law, intention is very important. If the intention is very apparent, then we can say that the transfer is done. But in this case, you only use it as a means to dodge some documentation. But the son wanted to take the property, but the court held that your father never intended donating the property to you. He just wanted to use this so that he can get a loan. So that is the first thing. So one, when in intervivals, where the property will be given to you before the person dies, the intention must be clear. And it must be acquired through, it shouldn't be acquired through fraudulent means. Right, that is number one. Number two, another way of donating a property is what you call, when you write, what you call testamentary disposition, and we call it the will. In Ghana, there's a law that governs a will, and it is the Act 1971, Act 360. The law says that a will must be in writing, and you can only write a will when you are 18 years and above and you have sound mind. And it should be in writing, it should be signed, and it should be attested according to Section 2 of the Act. So every will must be in writing, it should be signed, and it should be attested. We look at cases that will make us know. The signature to a will is very, very important. The case of Ria Abakan, in Ria Abakan, the person wrote a will, then he signed the last page. After that, he wrote other pages, which he didn't sign. After his death, when they wanted to take a probate, the court held that because he signed only the first page, the other pages that were not signed are not enforceable. So when you are writing a will, make sure that you have signed all the pages, or the last page is signed. And the last page that is signed would enforce the will. In another case, in Regrove, a will was rejected because only one witness. And another thing about a will is that when you write a will, two people must witness it. And the law is saying that when you write a will and you are signing, the testator, when he's signing, the two people should be present when the person is signing the will. So you don't write a will and you give it to one person to sign, then you go and call another person to come and sign for. No, when you are signing, the signing must be done in presence of those two witnesses. And all the two witnesses must be present, and they should see that the will is being written, is being signed. And after that, those two witnesses too, they must also sign in presence of each other. In Ekua, Manfo versus Margaret Akosua Jimai has given a constitutional backing by Article 2.1 of now, with the effect of Article 22.1 of the Constitution and 13.1 of this. It is saying that when somebody is in a marriage and somebody writes a will and he doesn't give you, Article 22 and Article 13.1 of the Wills Act will give you the authority to go to court so that equitable part of the property can be given to you. Again, when you are less than 18 years and your father writes a will and it doesn't include your name, both your spouse and the child who is less than 18. To be frank, when you are more than 18 years and your father writes a will and it doesn't include you, You cannot hold anybody liable for anything. Remember, after 18 years, your parents own you no more responsibility. So once you become 18 years, you must understand that you don't owe. Some people think that because they are firstborn, they are this, when their father died. No, when your father writes a will and doesn't give you anything, when you are more than 18 years, you cannot make any noise. Let it be known. And that is the position of the law. The highest law of the country, the 1992 Constitution, Article 22(1), requires that a person should be reasonably provided for from the estate of his spouse. This provision was not required to take effect only when marriage is thriving, but in all marriages. That means if you're a woman and you are with a marriage and your husband writes a will and it doesn't include you, Article 22(1) permits you to evoke it. And if you are less than 18 years, your father writes a will and it doesn't include you, Article 22(1) and Section 13(1) of the will permits you to evoke it. But if you are 18 years and you are a child, your parents own you no responsibility to give you any property. A typical case is a case of Henry Bonsu and others versus Queno. In this case, somebody wrote a will and he was having two children who were disabled. When the father was alive, he was taking care of those two children. But when he died, when he wrote a will and died, he didn't include those two children in the will. The mother took the case to court that these are my disabled children. They are not working. The father wrote a will and didn't include them. They were more than 80 years. The court held that, well, the law says that once the child is more than 80 years, he's not entitled to that. But rather, the court rather gave some property to the widow. And, I think sufficient property was given to the woman so that he could take care of the woman. But the children per se were not entitled to the property because they were more than 18. And you should be able to know that once you are more than 18 and your father writes a will or your mother writes a will, you are not entitled if it doesn't include you. The third one is what you call the customary law. The customary law is normally what you call the oral will. When somebody is about to die, he will call people and tell them that when I die, this one should inherit me. When I die, this cocoa farm should go in. That one is oral. And it's like intervivals, where you bring people to come and witness. Customary, we do that a lot. And the law is saying that in Samanso is deathbed disposition of the deceased self-acquired property. It represents the dying wishes of the deceased and it is enforceable. Much ink has been spelled out by judges in propounding the essential elements of a valid Samanso. The famous formulation by Leni as was in Suman versus Yehunu and Akele versus Kofi, and can be summed up in three essential characteristics. First, the disposition must be made before witnesses who know the contents of the declaration. Secondly, some of the witnesses ought to be family members who will have inherited the maker of the disposition when he died. And lastly, there must be an acceptance. Like I said, when you give it as intervivals, as in Samanso, you have to call somebody from your family, somebody from the person who are going to give the property to family, and then a third party who is not there. Then after the property has been given, you have to thank the donor. And you the donee or you the beneficiary, you have to thank him when he's alive. Then the property transfers. In Abiyoa versus Manfo, they disagree with that, in that judge was saying that even if you don't bring your family member to come and witness, the property is yours. So you can decide to dispose it the way you like. And I totally agree with that argument, because there are some people, they come from the family. Once they see that you are giving a property to somebody who doesn't belong to the family, they resist it. But here we are talking about properties that belong to you yourself. So nobody can dictate what you should do. Let me take this opportunity to explain that if there's a family land and you build on it, that property belongs family property. It doesn't belong to you as a person. So you have to be careful when you are putting properties on family land. That is why those days, our foregrandfathers, those days what they do when they are building, they will build the first compound house, and at the back of the compound house, they put up something like a kitchen. It is that property that they bequeath to their wives. And he will give the main building to the family, then give the kitchen to the wife. And it behoves on the wife to make sure that when the husband is alive, he will help her to complete the house before he dies. And normally what most of these family members were doing is that they will build the main building on a family land, then they will go and build another one on a family land of the wife, so that the family members of his family cannot go to the family land of his wife. Because everybody knows that when you put a property on somebody's family land, the property belongs to that family. That is why in their wisdom those days, the man will put up a house on his family house and go and create a kitchen on the family house of the wife. So that in case he dies, the family of the man cannot go to the family of the wife, because that land doesn't belong to the man. And they were wives. We should be able to look at this, and that thing did not create any progress for them. But where you, the man, you put a house on your family land, then you put the kitchen of your wife on a family land. Once the property is on a family land, the property will belong to the family. So it is advisable you go and put the kitchen on the family land of the woman. Then you put your main house on your family house, so that you can give some of the property to your family members and allow your wife to develop the one on her family land and becomes hers. And they did that. It is great of today that we do not understand how our people are doing it. It behold on us. And the Lord is saying that for lack of knowledge, my people perish. They did that and there was no conflict. But today, people will not understand it. So it is advisable not to be putting properties on the family lands. Once you do that, it becomes the property for the family whom the property is built on. If you have this property, if you do these three ways of going about it, either you do intervivals, either you do a will, you do samansu, it's your own property, you'll bequeath it the way you want. But if you don't do it, the law will do it for you. That is where the intestate succession law will come. PND's law 1985, PND's 111. In that case, when you don't write a will, or you don't do intervivals, or you don't do samansu, and you die, the law will distribute the property for you. And when the law is distributing the property, the law always look at 4 people. You look at surviving spouse, look at surviving children, look at surviving parent, and customary inheritance. So when you die right now and you didn't make a will, the law will distribute it to 4 people. The first person is your wife, and they will give them 316. The second person is children. They will give them 916. So they will give it to the children, and the children will share. In Ghana, we don't have anything like illegitimate child. That means in Ghana, there's no child called legitimate. Once you have a parent, you are a child. Even adopted children who are not biological children are also children. So if I stay with my nephew and I adopted him, he also have the same right. And when they are sharing among children, they share equally. They don't say somebody is older than somebody. Then the third one, 1/8, goes to the surviving parent. If the parents are not dead, you died before your parents died, then 1/8 of your property will go to your parents. Then 1/8 in accordance with the customary law, the customary successor. But if at the time that you die and you don't have parents, then the 916 that goes to the 1/8 that goes to the parent will be distributed among the surviving wife and the surviving children. If perchance, as at the time you die, you don't have a child, you don't have parents, then the property, 2/3 will go to the surviving spouse and 1/3 will go to the family head. So we have to know that that is where the law will distribute the property for you. There's a pending case in Parliament where they are trying to adjust some of the way the properties are distributed. So when they are able to pass the law, they couldn't pass it. And I don't think they will be able to pass before this Parliament brings up. Where there's no surviving parent, 1/4 of the residue of the estate should divide in accordance with customary law. So when the person doesn't have parent, then it will be added to the customary successor. The law also creates a presumption against survivorship pursuant to Section 15. There's one funny thing. Assuming a man and a woman are traveling and they die, and we don't know who died first, the law presumes that the older one died before the younger one. That is what the position of the law. So you see, in most people try to avoid traveling in a group with a family. The law says that sometimes it is risky to travel with the whole family. But Comoros, they say that when 2 people die, I don't know who died first, the older one is assumed to have died. There's another thing we have in law about will. When I write a will and I bequeath it to my son, but unfortunately my son died before I died, then that property has lapsed. And that property has lapsed. Sometimes when the person dies, then the children of the parent, the child who died will come and say that our grandfather gave it to our father and our father is there, so automatically it's for us. So if your father died before his father died, then the property will lapse. What is in the will not work. There's another thing we call a deem in law. That one too, when your father have a property, then he bequeathed it to you. But unknowingly, he has already sold that property before he died. Because he sold the property before he died, the property has become a deem. Again, when I have a will and I'm writing, I would normally say that my administrators, people are appointed to distribute the property. Those who are distributing the properties, they are given the opportunity to pay the debts of the testator before they start distributing the property. And when that happens, the administrator can pick any of the properties and sell it to pay for the debt of the testator. If you are not lucky and your face is not nice, and the testator pick your property and sell it to defray your father's cause, then your property has become a deem. So it is important you look at some of these things. So I would pray with everybody that as you are living, have good relationship with your father, your mother, so that he can remember you and put your name in the will, especially when you are more than 80 years. Other than that, your father owes you no obligation. The last one we call the trust. A trust is a form of estate donation where people don't want to use their face. In the first instance, the person donates the property from himself to another person. But in a trust, the owner, the donor, will appoint a third party and allow the third party to administer the property for the benefit of a third party. Unlike the first 3 ones, where the donor directly make the transfer the property in survivors through a will or through some and so, or probably through PNDC 111. With trust, the person will appoint a trustee. So let's assume that I'm the donor. I'll appoint Peter as my trustee. Then for the benefit of my child, probably I have gone to give birth outside my marital home. And I don't want my wife or my children to know that I have a child outside home. When I do that, I'll appoint Peter and create a trust in the name of Peter. Then I'll tell Peter to use the estate to take care of that my child, whom I don't want my wife and my children to know. So I become the donor, or settler, then Peter becomes the trustee and my child becomes the beneficiary. For us to know this, we have to know certain things. Trust is defined as an equitable obligation binding a person who is called a trustee to deal with a property over which he has control, which is called the trust property, for the benefit of persons who are called the beneficiary, or of whom he may be one or two. So private trusts are divided into three: express trust, constructive trust, and resourcing trust. Our focus will be on a resourcing trust. Let's explain what is express trust. The express trust is where I create the trust and I tell Peter expressly what he should do with that property. Constructive trust. In constructive trust, your conduct will show whether you are giving a property to somebody or not. Let's assume that when I was alive, I gave one of my properties to one of my nephews, and I allowed my nephew to stay in. He stayed in that house, was not paying rent. Then when I die, then you come and say that the property should resort to my estate. No. Constructive trusts are trusts. Constructive things are things which just give some apparent indication. Another way of talking about constructive trust is you open an account with a bank. Then, as a banker, you become a constructive trustee over the money for the benefit of your customers. That is why you have to be careful to know that you only release the money to according to the mandate given. Another way of looking at constructive trust is like we look at the conduct of people. Let's assume that you are a man. You have a daughter. He has a boyfriend. The boyfriend has been coming to the house. When he comes, he greets the father. When he greets the father, the girl goes out with the boyfriend to town. Then one day somebody sees your father and say, "Oh, Papa, could you me who was so namo? Also, me ni masibia. Yemfo bia mechiame." No, there's a constructive notice that you have given recognition, because when the man comes and takes your daughter away, you agreed. So sometimes certain issues are done constructively. It is not everything that we say it expressly. Then the last one we are talking about is the resulting trust. In resulting trust, you don't actually expressly tell somebody that you are giving a property to him. Like in the express trust where I appointed Peter to become the trustee for the benefit of somebody. But in resulting trust, because you don't want somebody to know that you own the property, you give the money to somebody to do it on your behalf. Let's assume that it's me, and I want to acquire, because maybe I'm a politician, I want to acquire some property. I don't want anybody to know that the property is mine. I will go and I will use Peter's name to acquire the property, but I will pay for the property. If I'm able to do that to show that I actually use my money to acquire the property, and in the name of Peter, it becomes a resulting trust. Another way of looking at resulting trust is that in law, when a man marries a woman, the woman is entitled to advancement. What it means that when a man marries a woman, the man is supposed to keep the upkeep of the woman. He should give the woman accommodation. He should give her chop money. He should feed her. He should clothe her. So if perchance the woman, but the man is not entitled to advancement, it's the woman who is entitled to advancement. So if perchance the woman gives her money to the man to put up a house, and the man put up the house in his name, it's a resulting trust. Although the house is in the name of the man, the money came from the man, came from the woman to the man. But the reverse is that if you're a man and you give your money to a woman to build a house for you, that one cannot be a resulting trust. Because the woman is entitled to advancement, he can say that it was his chop money he gathered to build the house. So when a woman is giving, in a case of Rena versus Rena, there was this woman, who was a clothes seller. He gave his money to the man to put up a house. But when the man was putting up the house, he put the house in his name. Later, the man's family wanted to claim the property. The law went in and he was able to prove that it was the woman who gave the money to the woman to build the house. And everything shows that the man was not working and that even the man was depending on the woman. So it was a resulting trust. So when a woman gives you money to be used in building a property, become a resultant, but the opposite is not for the woman. In the case of Real Cranton and Adu Cranton and others, it was said that in essence, a resulting trust was a legal presumption made by the law to the effect that where a person had brought property in the name of another, that other person will be deemed to have hold the property in trust for the true purchaser. It was a trust implied by equity in favor of the true purchaser of the estate upon death. So don't think that if somebody gives you money to buy a property and you purchase it in your name, automatically it's yours. If that person is able to prove in court that it was he who gave you the money, it is not yours. The fact that it is your name cannot be yours. So resulting trust is very important. There was another case during the Achampon regime. Some soldiers were permitted to acquire some state houses in Dansuma. One of the army men, he bought one of the properties in his own name and bought another one in the name of his driver and allowed his driver and his wife to stay in the house. Then the driver died. When the driver died, the family of the driver and the wife wanted to say that because the property was in the name of the driver, the property belongs to the driver. Meanwhile, the document was with the army officer. When the case went to court, the army officer was able to prove that one, that scheme was not even for the driver because the driver was not even a soldier. Two, it was his money he used to purchase it just in the name of the driver. So it becomes a resulting trust. So whenever you are doing some of these things, the law permits, if you want somebody to do something on your behalf, although it is in somebody's name, you have to find a way. Either you keep the receipt yourself or you can enter into another collateral agreement behind the scene to show that I have given this money to somebody to buy this on my behalf. Other than that, upon your death, you have problem. The presumed resulting trust may be rebutted by counter presumption of advancement. And this arises where the person provided has equitable obligation to support or make provisions. That is what I've explained. That wives are entitled to advancement, but husbands are not entitled. These days, a lot of women are thinking that when they divorce with their husband, or they will get 50% of the property. In Mensah versus Mensah, that thing was there. But in Quasin versus Quasin, it was held that in Mensah versus, it was held that the woman must provide substantial support. Substantial support. That means there should be evidence to show that the woman also helped the man in so many ways. One of the ways is either he washes your tea, he cooks for you, he warms your bed. It's also another form of giving support. And he's entitled to it. So, to extend, that is what resulting trust is. To this effect, when a gift is made in the name of another person, equity would deem it that said person hold the property or gift in trust of the actual buyer of the property, the true purchaser. Like I'm saying, if I give you money to buy something on my behalf and you use your name to get the receipt, don't assume that the mere fact that the thing is your name doesn't mean it's yours. If I can prove that the money came from me and I only sent you to go and buy it, but the receipt was just in your name, then it's a resulting trust. However, this presumption can be rebutted when the purchaser has an equitable obligation to support the person in whose name the gift has been given. That is to say, when you have a woman and you give the money to her to build the property, because he's entitled to advancement, that one, the resulting trust will not apply. But if you're a man, it will apply to you. If you're a man, it will be applied to you. So you have to look at that thing very well. The presumption can rather be rebutted irrespective of the equitable obligation. Another thing is that let's assume that you are a man. Then you tell a woman that you are dashing the property to him. We call it promissory estoppel. You are dashing the car to her. And you follow the girl to take the car to a welding shop for the car to be welded and sprayed. Then after that, you say you are taking the property back. It's an esto. You'll be stopped from denying. If you're a man, you take a woman to a room, then in the act, you promise that you are giving the cocoa farm to her. Then the following day, the woman, based on that promise, you follow the woman to go to the cocoa farm. You go and help some laborers to weed under the cocoa farm. You'll be stopped from denying that you have not given the property to her. That is another topic, but that's not what you're. So the presumption is that in the name of the lady. So when you do that, we should look at the person who has advancement and the person who doesn't have an advancement. Then we can have another trust that can be created for children who are less than 18 years. You can create a trust for children who are more than 18 years, and you can have a trust for children who are less than 18 years. So when you create a trust for a child who is less than 18 years, you can say that when the child becomes of age, the property should be transferred to him. But during the time that you, the trustee, is looking after the property, you cannot transfer it. In most cases, when people are appointed as trustees and they die, their family members come in to behave as if, because their family member was a trustee, they also want to inherit the trust. You can't do that. Unless the donor agrees that a family member should also come and continue. Other than that, the donor will have to appoint another person to look after the property when he dies. The last aspect of our topic is on Islamic law. In Islamic law, they are looking at religion and they use the Sharia law. In Islam, they are saying that it's the Quran that distributes properties, and they give preference to men than women. Because of that, a lot of Muslims are now adopting the Bible's way of giving properties. Therefore, if a Muslim thinks that his firstborn is a woman, but because he knows that the Islamic law will allow the property to go to a man more than a woman, what the man will normally do is that he will donate or give a gift deed to the daughter before he himself will die. So that when he dies, because the property has already been given to somebody, it will not form part of the estate when he's going through distribution. That's why a lot of young men, when their parents have money, because they are the firstborn, they go around chesting that, oh, I'm the firstborn. When my father died, I'll get the elephant share. Women, if you know your husband has inherited his uncle, when he dies, the property will not come to you because he inherited it as a family property. So make sure that you try to acquire your own during the pendency of the marriage so that it will be separated from the family. In the Islamic distance, they have a way of doing this purely by the Sharia law. And the law, the Islamic law says that encourages the practice of charity giving. So even the Muslim also have a planned way of donating. They call it salah. So a Muslim can even donate part of his property before he dies, and he will do it through the survivors. That is what we have for today. Thank you.
Great, great, great. This has been an insightful presentation. And so our participants, if you have a question, you can unmute yourself and ask your question. Richard Atta Esquire has given us a lot of insights today on estate and gift planning. And so if you have a question, you can just unmute yourself and ask your question. But before that, I have a question here. I have a question here for you, sir. So someone is asking, how does effective estate and gift planning bring wealth and its sustainability? How does effective estate and gift planning bring forth wealth and its sustainability?
It does so because the owner of the property wants the property to be used or distributed in certain way, according to the way he wants it to be done. And wealth grows when investment is increasing. So the owner of the property wants to leave it with somebody who can continue to retain or sustain the wealth of the property. So the best way to do is for the donor to say the way the property should be used, either when he's alive or he's dead. Because when he's alive, he is using the property in his own way. So when he's going to die too, he has to decide how the property should be said. And the only way that property can be sustained is when he plans and decide and do what he wants to do. If you don't do it, then the law will come and do it for you. And that may not obtain the wealth. Because most people who inherit properties and don't know how the property will occur will normally have. That's why people want to give properties to those they know can take care of their property. There are instances of people who has money and they have their laborer in work with. But because they can see that the laborer is more enlightened than his own child, he will bequeath the property to the laborer, or the laborer. A typical case, the prince of, I think, Dubai. The father has two sons, and the elder son inherited the father. Now, the first son, who is now the king of Dubai, he has wife and children. But the man sees that his wife and his children are just enjoying themselves. So he make a decree that when he dies, the inheritance will go to his brother. Because he can see that when the property goes to his children, they will not be able to sustain the gains they made for Dubai. Right. So he has made that thing so that the sustainability of the world will continue. So when in Ghana, people say that thing, and you see them going around misbehaving. Yeah. These days, when they are coming to appoint a chief, it is not just you being a royal. They look at other things. In Masi, when they wanted the late king, who had wanted the current to inherit, that child, Nana Kwekudia, was sent to the and he was trained the best way to become a king. Yeah. So when he went to Tekima, he didn't stay in Mekia. He went to stay in Tekima. He was made to go through the rudiments of life. So when the time came and they were going to appoint him to become the king, they selected him. They were equally other royals who become king. But here was somebody who has been trained. He take over the kingship so that he can sustain the kingship the way they wanted. So planning of all those things is to sustain wealth and even sustain inheritance.
Great. Great. So we have to be intentional about our succession and who takes over from us. Very well elaborated. Valentino, I can see your hand. Yes. You can go ahead.
Great presentation, Sir Arthur. Two questions for you. The first question is, if someone doesn't have a will, what is the ruling body? Statutory law, tribal custom, or religious custom? Or does a judge make the decision taking into consideration all three?
In Ghana, if you don't make a will, then the PND's law 111 is the one that rules. That is the position of the law in Ghana. But if you're a Muslim, the Sharia law rules. So if you're either a traditional, even if you're a traditionalist, the PND's law will distribute the property. Ever since the PND's law 111 came, the customary law per se is not the one that rules. So don't make mistake. It's the PND's law 111. If you don't make a will, the PND's law 111 will distribute your property. There's always the conflict of people trying to bring the customs to distribute property. That is wrong. PND's law 111 is the one that raised. Unless you allow it to, it in the law, provision is made for the customary law. So that is why it is to be distributed, and a portion of it also goes to the customary law. That is why the customary law prevailing in that community will rule. But the PND's law 111 is what prevails when you don't write a will. But if you're a Muslim, the Sharia law rules.
Thank you. A second question, does title and beneficiary selection, like with a pension or life insurance, have more power than the will? So if you hold title in the name of the trust, or you have your beneficiary selection to a person, does that have more power than the will allocating those assets to someone else?
Yes. If you are in the army, the police, what you do there, by law, you can't write a will to go and change it there. When you have a pension and you put something in there, you can't change insurance because it's a separate contract from the will. Unless
you can change that beneficiary selection at times in the future, but if you don't, it goes to what you said.
You can't use the will to change it.
Yeah.
You can't use the will to say that I appointed Peter to become the beneficiary for my pension, for my insurance. Then in your will, you appoint James to become the beneficiary for the pension and the insurance. It's not done. Because it's a separate contract from the will. If you want to incorporate the beneficiaries, the pension, and the insurance, you should be the same name in the will.
We saw that as big mistakes with someone names an ex-spouse, their original spouse, the beneficiary in a life insurance policy and a pension. They get divorced, and years later they pass away. Instead of things going to the new spouse or current spouse, it goes to the old. It creates an embarrassing situation and a complicated one, right?
Yes. If I make insurance, and that is why the insurance people will not be able to use words like my wife. No. You should stay Mrs. Jane and Mrs. Janet, Mrs. Grace Mason. There are two people. So you are specific, expressive. Because of this problem, these days, the names are very important so that they become the actual payee, become the benefit for it. But if you go and write my wife, it's too ambiguous. I don't think any insurance company will allow you to say that my wife will not bring in the name. If the name is brought, these days in Ghana, insurance and banking, they ask you to bring the government card or Ghana card as evidence to prove the identity of the person. So therefore, those problems has been ironed out in our signature now. So that when I write Mrs. Esther Atta, he's a beneficiary. In case I divorce him, then go and marry another woman, and it's not Mrs. Grisata. It is Grisata who will benefit, not Esther Atta.
Great.
Thank you.
Great. So yes. So our time is almost up for this section, but we have one more question that I would like Mr. Arthur to address for us. So from your many years of professional experience, what are the most common mistakes you see clients make when planning their estate and giftings? Maybe you do with us, and then we move on to our next presentation.
A lot of people think that when they write a will, they are going to die soon. And because of if you write a will. A lot of women also think that once they become Mrs., automatically the properties of their husband become theirs. That is also not correct. And a lot of people too are not writing will because they know when the beneficiaries goes to know that they are the beneficiary, they find a way to kill the donors. So people normally don't want people to know the contents of their will. Some of the spouses, some of the relatives, when they got to know that wills have written and they are not benefiting, then they start having problem with the donor. So a lot of people keep their will secrets so that when they die, most people too are having problems, especially when they write the will, they don't tell anybody. Then they go and deposit the will at the courts. Many people has been there. They've even used letters of administration to distribute their property. Only later, the family will get to know that the man wrote a will, but he never told anybody. So it is important when you are writing a will, at least you let one or two people know. Even if you are not telling them the contents of the will, you tell them that you have a will. And normally these days, because photocopies are available, you can even put photocopy of the receipt of deposit at the court. Normally, when you write a will, you have three copies. One may be kept by the lawyer, one will be kept at the court, and one will be kept by the donor himself. In most people, they put their wills at the bank as a state custody, and they will keep the receipt. And when you do that, that will be fine. Okay. A lot of people too are fighting over property when they don't understand that he thinks he's the firstborn and his lastborn has more properties than him. As for donation of property, is the testator or the donor who decide how the property to be shared. I can not give anything to my wife. That is why in some cases, some men, when they're about to distribute their property, they divorce their wife so that they can have peace to distribute their property. That people can do that. People are capable of doing many things. And in some places, if you look at most of our can women, they think the property will go to the woman, Martha, and they think when they give the property to the men will give their wife, the property will move away from the house. If you go to the paternal inheritance, they also believe that property should go through the men's side. So they prefer giving the property to the men more than the wife. But today, what the man and the woman can do better. So you decide whom you give the property. And I think when you are giving property, you should give property that will help the child to be self-sufficient in future, not necessarily being the owner. I think lazy people should not be encouraged to be giving property. You should be giving to people who can help to increase or bring more investment into the property.
Great. Awesome. Awesome. A lot of insights, a lot of information have been shared with us. And I believe right from here, if you don't have a will, this is the best time to start creating one. If you have one, this is the best time you need to update your will. Yes. And like he said, he mentioned about paperwork. And so now we are moving to our next presentation, and our presenter will do this in less than 30 minutes. Yes, he's going to give us an overview of what financial planning is about. Estate planning is one aspect of a comprehensive financial plan. And so we want Mr. Valentino Sabuko to give us an overview of what financial planning is all about. And then we will bring our webinar to an end. So, ladies and gentlemen, without wasting much time, let's welcome Mr. Valentino Sabuko. He is Executive Director for the Financial Awareness Foundation, and he's based in California, Sonoma County in California, USA. Val, the floor is yours.
Thank you, Peter, and happy Estate and Gift Planning Awareness Month to everyone. Have you received the financial literacy quiz? If you have, and you've answered the questions submitted, we'll talk about that in a second. If you haven't, there's a link that was just in our greeting that you can download, and you can take this at a later time. It's an assessment of your knowledge in the financial awareness and literacy area. We've given this quiz to thousands of people over many years. Many people believe they have a good handle on personal finance until they find out there's areas they're totally blindsided to. When we give this assessment quiz, thoughts to consider to people, most people answer about 10 of those questions with a yes, which means 10 of those, they're either not practicing financial awareness or literacy, or they're blindsided by them. Any one of these elements happening at the wrong time could have a major negative effect on our finances, and we find it does. Globally, we're experiencing a financial illiteracy epidemic. Rich or poor, money touches everyone, and how we manage and deal with that money is the variable of our knowledge and how we apply that to it. Will improve financial awareness and literacy increase your bottom line, the bottom line of your company, the bottom line of your country? We think it will. We did this as an economic analysis and economic brief in a webinar we had with the University of Nairobi and the University of Ghana several months ago. We outlined several economic indicators, about 20 of them here, from a database of over 500 that come from the United Nations, the World Economic Forum, other international data courses that's looked at globally for making economic decisions. We compared them with a variety of African countries and benchmarked them to China's economy and the US economies, two of the largest and strongest in the world. We found that with the population of Ghana of 33 million people and a GDP, which is a gross domestic product, which is all the goods and all the services produced in that country, when we divide that by the number of people, we find that the GDP per capita is around $2,200. For African countries, this is fairly good. South Africa is the highest with about 7,000. But when we look at the DRC and Ethiopia and Uganda, we have countries that have less than $1,000 per person as a result of the overall economic development. When we compare this to China, that's got $12,000 per person, or the US that's got $77,000 per person, this is very low. When we look at inflation and unemployment and the percentage of workers that are in agriculture and the poverty rate, we find this to be very interesting data. We find that the ag workers throughout Africa are over 55% of the workforce, yet they don't produce enough food to feed the people. The poverty rate throughout Africa is in the 80 to 90%, people worrying about putting food on the table and feeding their families. In other parts of the world, the workforce is well under 50%. In many places, it's under 10% where they can produce enough food to feed everyone and have exports and make money on it. We also find that the infrastructure in Africa, in Kenya, in Uganda, in Ghana is different. In Uganda or in Ghana, we have some of the best internet connections that are throughout the continent. Yet we're experiencing today, some of the presenters couldn't get on because of the internet. Only 68% of the population in Ghana has access to it. In some of the African countries, it's as low as 6%. But also road, rail, port, and air are very weak, which makes it very difficult to have economic development. We also see that female in government is very low in Ghana, as it is in many of the African countries. Even in the US, that's been promoting gender equality, when we did this data, I was surprised to see that the US is only at 29%. Yet female represents half the population. An interesting financial piece of data is the female globally controls about 75% of consumer spending. but the female globally is not provided much financial education. Today's presentation is educational. We're not practicing law or practicing tax, investment, any type of legal advice. We're just sharing some financial knowledge with you. Your particular situation is unique and should be looked at with your professionals to give you assistance. So, what is financial literacy? It's the understanding and the effective set of skills and knowledge that help you understand and make informed financial decisions. Unfortunately, globally, we don't talk about what those key elements and skills are. In most of the definitions that's used globally, it doesn't talk about dealing with paperwork, inventorying what you own and owe, understanding how you make money, understanding your employment benefits, talking about your life goals, planning for retirement and financial independence, dealing with the purchasing of major expenditures, investments, dealing with tax, risk management, or we've heard from Sir Arthur, estate and gift planning. You don't want your future to be a gamble, do you? Looking at a typical life cycle, we start out getting educated, and those in the audience that are teachers do a great job trying to teach our young people information, knowledge, skill sets. After getting that knowledge, they go into the real world. And in their early 20s and 30s, they begin accumulating things. Their family formation grows. They're accumulating more assets and growing during their middle life. Then as they reach the senior parts of their life, they're consolidating assets, spending, gifting comes into place. They pass away. What is your net worth? What do you own less what you owe? Would you benefit from a systematic approach to managing your finances, knowing the secrets of smart money management, making the best informed financial decisions, having the best chance for a secure financial future, having a roadmap for your success? We developed this, we call the FA Affinity Lifelong Learning Symbol, as a tool to help people better understand the elements of financial awareness and literacy, and then apply it to their own situation to give them the best possibilities of success. Will financial planning be a key to a secured and successful financial future for you? Food for thought. Creativity is intelligence having fun. Creativity is seeing what others see and thinking what no one else ever thought of. Creativity. Those of you in front of the screen now, pull out a piece of paper and put together 9 dots in a row of 3. And question, using only 4 straight lines and without lifting a pencil from the paper, how long will it take for you to touch all 9 smiles? You can't lift your pencil from the paper, and you can look at the screen if you don't have a paper in front of you and try to do this. You can only use 4 straight lines, but you can't lift your pencil from the paper. So if you go across here, that's 1, down here, that's 2, that's down here, that's 3, and that's up here is 4. That's 4 lines, but you didn't touch this dot. I'll give you a minute to do that because we're short of time, but you can also share this with family and friends. It's very interesting mental exercise and really opens the juices, the creative juices to thinking and planning, which are very important not only in life, but in dealing with your finances. Has anyone figured that out with the show of hands? Okay, let's go to the solution. The solution to that is thinking outside of the box. If you draw one line down beyond the dots, and the second line covering those dots, and the third line covering those dots, and the fourth going through all 9 dots, you've accomplished something pretty special, didn't you? Creativity is intelligence having fun. So, getting organized is the first element in personal finance. And it's a very important life skill that I hope we're teaching our young people, that can be taught in primary school and secondary school, having nothing to do with personal finance, but teaching a very important life skill. Here, as we look at the getting organized area, we start with managing paperwork, tracking what we own and owe, our net worth, managing our cash flow, how we make and spend money, and then understanding and taking advantage of employment benefits. An action plan would be a prime time to begin getting your financial house in order. And you might start by doing this by getting a 3-ring binder and start developing your own personal financial plan. As we move through this Affinity Lifelong Learning symbol today, we'll be giving some thoughts and ideas around this. We also have a free set of publications and materials we'll give you afterwards that can allow you to go through this in much more depth. So, paperwork. What do you do with your important papers? Where's your identity card, your birth certificates, your passports, your insurance policies, your will if you have one, your vehicle registration, your investment certificates? How do you organize your paperwork? In the olden days, it was just dealing with hard copy documents. Today, we're dealing with digital documents that in some cases are considered legal and formal documents. Other cases, they're not. What type of filing system do you have? Have you gotten a credit report? Credit report could be an important tool to help you get financing at a much lower rate. Who are your advisors and financial product providers? Do you really need them? Properly used, will they give you knowledge to help you better manage your position? Like what Sir Arthur talked about in estate planning, shared a lot of knowledge. I'm sure a lot of us on this call didn't know. So being able to find trusted advisors to help us on estate matters, on tax matters, on business matters, on investment matters could be critical. But we also need to know how they're compensated. Are they working for you? Or are they just trying to sell something as a salesperson? So we want to select and use advisors properly. Net worth, number 2 on the affinity sign. Do you know what you own and owe? The assets that you have, these are things that you own. They're important for living your lifestyle, but also for building wealth. Liabilities, what you own, this is things you have to pay back, things that you've borrowed money for. And the difference between assets and liabilities is your net worth. Businesses use this as a tool they call financial statements that are produced monthly to operate and run businesses. Households very seldom do this, other than maybe when they're getting loans or financing for some reason. But it's a great benchmark to see how you're progressing financially. And we suggest you do this each year, inventorying what you own, and then looking at it and seeing if you're progressing well and how can you improve that situation. Your net worth is not your net worth to the world is usually determined by what remains after your bad habits are subtracted from your good ones. That's a quote from Ben Franklin. Cash flow, number 3 on the list. Income versus expenses. Where does your money come from? Where does your money go? Have you found the balance that works best for you? If your lifestyle requires more money than you're making, then maybe you need to get a better job. Maybe you need to get more education to get the better job. Maybe you need to do other things to improve the balance between what you earn and how you spend your money. Beware of little expenses. A small leak can sink a big ship. Understanding your employment benefits, your hidden paycheck. Employers globally are spending somewhere between 5 and 40% of salary in benefits or taxes they pay for their employees. Many people getting a job don't look or understand those benefits, in many cases don't use them or buy after-tax items that are already included in their benefits. So when looking for a job, compare benefits along with salary. And if you already have employment benefits, review them annually to make sure you're using them most effectively. Now that we're organized, how about financial planning? How does that come into place? You don't need a special set of skills to manage finances or build a solid foundation for your future, but you do need to understand certain financial principles. Will financial planning be the key to your success? Here are some tools that could be very important for you. But first, here's a little tool for problem solving, because part of dealing with personal finance and managing finances is trying to make things better, making things better for you. What is the formula for successful problem solving? First, you define your goals. What's important to you? Then you analyze your situation to see where you're at in relationship to your goal. Then you look at what strategies can you develop that will take you from where you are today to where you want to be. Select the strategy that's best for you, and then implement it. And then you want to track and monitor it. If it's a small item that you're purchasing and you've gone through the review and done your due diligence and you've purchased it, you've completed the problem solving. If it's a longer item like planning for retirement, you want to be reviewing this regularly to make sure you're on the right path and that you're making any appropriate adjustments along the way that's necessary to reach your goal. So if you don't know where you're going, you might end up someplace else. This is critical in looking at your life goals. Goals are not dreams. Here's a huge difference between a dream and a goal. A dream is something that we hope for. Goals are something that we plan and work toward, and are accountable, have accountable benchmarks. Where do you want to be in 3 years, 5 years, 10 years? What's really important to you personally, family-wise, financially? When do you want to retire? What gifts or legacies do you want to leave behind? Here's a few glossary items. A dream. These are thoughts to create in your mind that can take any shape or form that doesn't need much focus. But a goal is an objective or a target someone tries to reach and achieve through focused actions. Neutral mind. That's the balancing of positive and negative information before making a decision. The neutral mind is calm, centered, and precise. It's less attached to outcome and expectations of events and can be very interested in the truth. And this is important today as we look at things on the internet. It's not true that anything we see on the internet is true. And something we all need to be careful with as more information is being exchanged is the information we're seeing and reading current? Is it someone's bias or is it factual? And then values, a person or a society's belief about good behavior and what things are important, the principles that help us decide what is right and what is wrong and how to behave. What's really important to you? Now might be a good time to actually take out a piece of paper and outline what's important to you personally, what's important to you financially, to help us serve as a driving force for your future, to make your life better, make the lives of your family members better, make the lives of your students better. The sixth element, dealing with financial independence and retirement. What's in your future? At what age will you reach financial independence or retirement? Financial independence puts you in a position not having to go to work, to having the wealth to do what you want to do when you want to do it. That doesn't mean you don't work, but it does mean that you have a different element of freedom. Most of us work throughout our lives, hopefully reaching a point of financial independence by doing some saving and investing along the way, and then being able to reach that point so we can enjoy our life. What kind of rate of return do we need to earn on our money so that our money can be working for us and growing? Well, if you divide your rate of return by 72, or 72 divided by your rate of return, it will give you the number of years it takes to double your money. So if you have, if you're getting 72% on a savings account that you have, and you 7.2%, and you divide it by 7.2, you'll find that it takes 10 years. Interesting figure to see what type of wealth needs to be generated to reach this goal. Understanding time value of money and compounding, which is really important. If Peter could give us a check today for 1 million guineas, or Peter could give us a check today for a CD doubled every day for 31 days, which check would you take? If you only have 5 seconds to make the decision, or you get neither check, which one would that be? How many of you would take the check for the million CDs by a raise of hands? Quick. If you don't decide, you're not going to get any check. Well, those of you who decided taking the penny compounding every day, that's the right answer. A penny or a CD doubling every day for 31 days is almost 11 million CDs. This is compounding. This is something we saw in real life world with COVID recently, didn't we? A couple people got it first. They touched a couple more people. They touched a couple more people. And pretty soon it was infecting the whole world. This is an important piece of knowledge. And as you look at this, looking towards your future, what type of wealth do you need to accumulate to be financially independent in the future? This is a complex calculation, something that financial advisors can be helpful to work with you to determine, or you can utilize different software to help do it. Here's a link to a software program that helps with this kind of calculation. Major expenditures, the seventh element on the affinity symbol. Some questions to ask. Major expenditures are like buying a car, buying a computer, buying a phone, buying a house, starting a business, things that you don't normally do out of cash flow. When that expenditure comes about, are you buying it for personal pleasure? Are you buying it to keep up with the Joneses or impress people you don't even know or like, or because advertisements are encouraging to do that? Is that really something you desire or require or need? If you do a little bit of homework before making that decision, can you get that at a better price, at a better condition, or determine if it's right for you? Dealing with investments. Most of us cannot accumulate enough wealth from our jobs to be able to retire unless we put that money to work. If we keep that money under a mattress while we're working and we're dealing with inflation, each year the buying power of that money goes backwards and does not work or perform for us. What kind of investments work for you? What kind of risk tolerance are you taking? What are asset classes? What is diversification? These are terms that are very important in dealing with investments. There's only 3 ways that we can earn money. One is from income. This is income earned from dividends, interest, rents, profits, royalties. The other is growth. This is buying something and it increases in value and we sell it at some time in the future. And the third way is through tax savings, government programs that give you incentives to put money in different places. The combination of these 3 is what we call a total return. Different ways of dealing with investments put things into asset classes. Asset allocation, being able to diversify asset holdings, dealing with investment risks, and working towards your target return. Bringing this together into your personal investment policy statement and plan can give you the guidance that's needed to get the most success from dealing with your investments. Be patient. If a get-rich-quick scheme seems too good to be true, it probably is. The 9th area is dealing with taxes and understanding and planning for this. As you earn more money, you pay more in taxes. This is something in Ghana, it's something globally. The tax rates and tax laws are different in each country. But the taxes are what's used to provide goods and services to help the country and the people of the country have better quality life. And if the leaders aren't doing a good job, then through elections, they're changed to help bring the best use of those tax dollars. But there's never been anything in any of the tax laws that we've seen worldwide that require you to pay a tip to the tax collector. So using the tax laws to your advantage, following the law, can save people many dollars that are wasted by not knowing them. So it's important to either understand and deal with your tax laws or to have advisors that can help you so you don't make mistakes or pay more than your fair share. Risk management, the 10th area dealing with personal financial management, is dealing with risk management and insurance, dealing with the areas that you can't afford to lose, and being able to plan for this, thinking in advance before a problem occurs, and then doing what you best you can to protect yourself. The 11th area is dealing with estate and gift planning. As we've heard earlier from Sir Arthur, if you don't have a estate plan, one that you wrote and one that you planned for and considered, the government has one for you. The government's plan doesn't take in consideration having a will, having a trust, having a power of attorney to help manage things. The government has a default set of rules for you of where things go when you pass away. You can change that by taking proactive action in creating your own estate planning documents and gifting. Everyone needs an estate plan unless you live forever. And at this point in time, none of us do. So it's something that's important for all of us. Question now, would benefit from using a systematic approach to managing your finances help you? We believe it's a powerful tool for most people. A special gift for you in closing, a gift of personal finance knowledge. This has been a very quick, rapid preview of very many complex issues. We'll have a link for you for a 10-month personal financial fitness plan where you can apply a little bit of this knowledge to each month, and at the end of the year, have a good personal financial plan. And if you follow this each year, you can manage this throughout your lifetime. We also have a gift for you in some textbooks that outline in more detail the knowledge that was shared here that you can download for free. If you're looking for some important causes to help make this a better world, you might be interested in joining the financial awareness and literacy movement in Ghana. It celebrates this month as October being Financial Literacy Month, and then 6 months from now in April, celebrates April is Financial Literacy Month, a time to learn about personal finance, encourage family and members to learn about it, and apply this knowledge. We have some interesting ways and easy ways to participate. And with that, I hope we got that into the 30 minutes.
Great. Thank you so much, Valentino. That was an intensive overview. Yes, you've covered the entire comprehensive personal financial plan, speaking about paperwork, net worth, cash flow, employment benefits, setting financial goals, planning for financial independence and retirement, major expenditures, investment, taxes, risks and insurance, and then estate and gift planning. And today our focus was on estate and gift planning. So Val, I have one question for you, and then I think we will wrap up the entire conversation. What is the link between estate and gift planning and the comprehensive personal financial planning? Where does estate planning come in when you are planning your comprehensive personal financial planning?
Each of the elements on the affinity sign, the core fundamentals and elements behind financial awareness and literacy, are all important, and estate planning is one of them. But estate planning is often eliminated, not even discussed when we talk about financial literacy, financial inclusion, nor doing business planning and business startups. This is often not considered, but it's a key element in helping to end inherited poverty. If we can build wealth for ourselves that we can pass on to our families, and our families can grow that wealth to pass on to future generations of family, not only does it help the individual live a better life, but the family to live better lives, but the community to live a better life, for the country to have sustainable economies. It's a critical element. And as you heard from Sir Arthur in our presentation here, by default, the government has rules for us. Each country has a different set of state secession rules without having documents, in different ways they interpret the documents and laws. You have an opportunity to make sure your wishes are taken care of. Please put them to use. Hope this has been helpful and wish you all the very best. Thank you.
Great. Thank you very much, Valentino. And we also want to thank Mr. Atta for that comprehensive presentation. And so this was our Estate and Gift Planning Awareness webinar in partnership or in collaboration with the Teacherpreneurship Network. It has been a good educational platform. We've learned a lot, and I believe we are going out there to change our financial actions and also improve on our financial inactions. If you have to write a will and you haven't, this is a reminder that you need to go out there and put your estate and gift plans in place. October is Estate and Gift Planning Awareness Month, and we are almost ending October. So our message for you today will be, we need to be intentional about planning our estates and giftings. We need to be intentional about building succession. All the wealth that you are accumulating, all the hard work, all the effort, all the energy that you are putting in, make sure you have planned who takes over after you have created all the wealth. When you are no more, who manages the wealth, who takes over, so that your wealth, your energy, your efforts can benefit the next generation. I always expand on this quote: a good man leaves an inheritance to his children's children. And so we all want to be good men. We want to be good women. And so let's be intentional about this. Let's plan our estates. Center for Financial Literacy Education Africa, we are significantly improving financial awareness and financial literacy education in Ghana and across Africa. We are doing this in partnership with the Financial Awareness Foundation, and we welcome everyone on board to join the improving financial awareness and financial literacy movement in Ghana and across Africa. We believe coming together, having a common voice, and working towards a society of financial literates, we will be able to help people build wealth and also end inherited poverty. So thank you so much for being part of our today's presentation. So we meet again. Go and draft your will. Bye-bye.